Call the fourth case on this morning's docket, case number 114601, Austin Jones v. State of Kansas.
Your Honor, I presume we have the state's indulgence to not make Mr. Fisherwood move.
That's correct. If you'll please wait till our new justice arrives.
Your Honor, may I reserve 3 minutes for rebuttal?
3 minutes is granted.
May it please the court, Kristen Patty for the appellant, Austin Jones. In 1977, the United States Supreme Court issued an opinion regarding law library access that really has no application here, except that it has a very interesting quote. The case is Bounds v. Smith. It's 430 U.S. 817. And it says, if the state files a response to a pro se pleading, it will undoubtedly contain seemingly authoritative citations. Even the most dedicated trial judges are bound to overlook meritorious cases without the benefit of an adversary presentation. And that's what we've been discussing a lot this morning. It's what we discussed when I was here a month ago for Breedlove. In this case, this is the one where the district court judge denied most of the allegations that the appellant raised in his pro se motion, but then asked the state to basically brief or respond to one. And then regarding the temporal argument that we had in Breedlove and was also earlier this morning, it was about 2 weeks then before the court adopted the state's response and denied that remaining allegation, which had to do with Mr. Jones's self-defense claim. Part of his claim of ineffective assistance of counsel was that his trial attorney was ineffective for not raising prosecutorial immunity for stand your ground defense earlier. And part of it also was that his trial attorney didn't adequately investigate his, not really alibi, but his corroborating evidence on his self-defense claim. One of the things I took issue with when I read the Court of Appeals opinion and when I filed my petition for review was that it considered that it thought that I had abandoned the self-defense part of it. And I think part of the problem is we've got, and it's something that I run up against a lot, because we didn't have an attorney appointed for Mr. Jones, I don't have an issue developed at the district court level that then I can really argue very well on appeal. I was trying to think about when I wrote this brief and filed it in May 2016, what I may have learned from my client through his letters. But of course that would not be in the record on appeal. And I can't argue anything to you or to the Court of Appeals that's not in the record. So yes, I think part of it, if the district court judge in this case looked at Mr. Jones's motion and determined that most of his allegations were meritless and didn't warrant a hearing, but there was this one, I believe that yes, the district court should have appointed an attorney to represent Mr. Jones and at least held a preliminary hearing with the state's response. And if part of it comes into play too with how important the self-defense claim is to Mr. Jones's defense. Basically, the first line of this court's opinion in Mr. Jones's direct appeal was that it was undisputed that defendant Austin Jones shot and killed Emmanuel De La Torre and Jesus Esparza on a parking lot outside of Jones's apartment on July 2nd, 2009. So this was his only plausible defense. And he was the only witness to testify, and without corroboration of his self-defense claim, he needed that to lend credibility. And his allegation is that his trial counsel didn't adequately investigate that. And I think I'm starting to flounder. I can't tell if there's going to be any questions. I guess we've discussed this issue so much. I think I'll have a seat unless Mr. Isherwood get up and see if there are any further comments on rebuttal. Thank you.
Thank you, counsel.
May it please the court, Assistant District Attorney Boyd Isherwood on behalf of the state of Kansas. What I alluded to earlier today, I reaffirm, I guess, now, which is we feel like this is, we don't take any issue, and I don't think we did in our petition, we don't take any issue with this being the type of case where appointment of counsel was needed.
Why not?
But
I was going to ask the same thing. Yeah, go ahead, Justice.
We feel like on this particular case that there is a when you objectively look at this, we feel like that you could easily see this being a situation on these very, very specific facts where the court reviewed something, was able to resolve two of the issues, and then felt the need to contact contact the state.
Well, what about the scenario I raised in the earlier case where the trial court is looking at the filing? Yeah, 2 or 3 of these don't merit much, but just in terms of, well, I may have a question here. Let me see what the state has to say about this before I make that determination. What's wrong with doing
And if that's articulated, then perhaps we would have a situation where it doesn't fit. But we just felt like this particular case versus the other cases that we've had.
Well, counsel, you use words like you feel like this.
Well,
and
we feel like
this very easily could be a situation. But can you be more precise and walk through the steps in the law that trigger the duty on the district court to appoint counsel in this case?
Our conclusion is based upon the case law that indicates if there's a potential. If the district court has determined there's a potential substantial issue,
and then you would presumably, correct me if I'm wrong, follow that up by saying the record in this case conclusively demonstrates that this district court judge found a potentially substantial issue.
That's our position based on these particular
Thank you.
facts.
By asking for the state to respond, that was in this case, not in every case.
That's correct. But not just by asking the state to respond, but by reviewing the motion, ruling. Not your scenario. Not, hey, I'm going to rule later after I hear everything, but ruling on some of the issues, and then asking for a response from the state on an outstanding issue.
Doing something different from the summarily dismissing what it had already summarily dismissed. That's what is the evidence in the record that the judge made a subjective determination that there was a potential issue, and that's what you're relying upon.
These are extremely particularized facts.
This is what makes it different from the situation before where you said that's just the motion, files, and records. That
would be
response was just part of the motion practice.
That would be the state's position in this particular case,
Got it.
again,
Okay.
based upon this Supreme Court's precedent.
Thank you.
So we don't have an issue with that based upon the precedent. We move on to what I don't know that I've seen, and perhaps it's out there and I'm just unaware of it. We move on to what happens next. What happens in the scenario where the district court should have appointed but didn't? And I think that the most apt characterization or test, I guess, that could be applied would be a harmless error test. And I think when you apply that test in this case, we definitely, in this case, see that if there was any error, it was harmless. And I
Under
think
what standard?
under the statutory harmless error standard. And again, it seems like such an odd phrase, but I suppose it benefited us, so we would have the burden to demonstrate harmlessness. And I think that the Court of Appeals, I think our petition does a pretty good job of explaining why, both legally and factually, this particular case would be considered harmless due to the possible feelings of res judicata based on the Supreme Court's direct appeal opinion. And then just factually, this is not the type of situation where immunity would have been found.
Does that conclude your presentation?
It does, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
I'm not sure I have a lot to say on rebuttal. I think for the most part, this district court judge did what normally we would like for a district court judge to do, which is we know that he reviewed the motion first before he asked for a response from the state on one issue. And I think certainly, even if someone would say that he didn't need to, he couldn't have been wrong if he had appointed counsel for Mr. Jones in here, because it came up with Mr. Isherwood, I do not believe that the error can be termed harmless. As I stated, we've got a potential at least of a corroboration of a self-defense claim that was not developed in the district court. And therefore, even though at least while it would seem that the prosecutorial immunity stand your ground defense from this court's opinion might not be completely viable, we do at least have a problem of, was there anyone else who could say and who could have supported Mr. Jones's claims in his trial? So, since there are no questions for me.
I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.